You know, in the modern courtroom, the smoking gun isn't always a gun anymore. Nope. More often, it's an email, a text message, maybe a single deleted file buried on a hard drive. But how does that little digital breadcrumb survive the journey from a computer to a jury, with its integrity totally intact? Well, that's exactly what we're going to break down.
This quote from all the way back in 1966 pretty much nails the core problem here. You see, the legal system is all about making judgments, what ought to have happened. But science, and that includes digital forensics, is just descriptive. It's not there to judge. It just says what did happen. And as you're about to see, these two worlds, the world of judgment and the world of fact, they don't always speak the same language.
So, that brings us right to the heart of it. When a machine is your star witness, and its testimony is just a bunch of ones and zeros, how do we actually know it's telling the truth? That's the puzzle we're going to unpack today.
So where do we even begin? Well, surprisingly, it's not with the technology itself. It starts with a person, the expert witness, and the really serious duty they have.
This expert, they are the first line of defense against getting it wrong, and their duty is crystal clear. Their loyalty is not to the person paying their bills. It is to objective, unbiased fact. Their only job is to help the court understand what the evidence actually says. That's it. Period.
And this quote, it's a perfect example of objectivity in action. Listen to the language. The expert isn't saying the defendant is guilty. Not at all. They're just laying out the facts. Here's what I found. Here are the other possibilities I looked into, and I found nothing to back them up. Their job is to let the evidence speak for itself.
But of course, staying neutral is a constant fight. An expert is always up against pressure from the emotional, sometimes horrific details of a case, from a client who is absolutely convinced they're right, or from a lawyer who's just focused on winning. Honestly, their biggest challenge is just keeping that scientific objectivity when everything is pushing them in another direction.
Okay, so once you have that objective expert, their work isn't done. Nope. The evidence they found now has to face its own trial. This is what we call the gauntlet of admissibility.
So what is admissibility? Well, think of it like a safety check, like a quality control process that's run by the judge. Before a jury ever gets to see a piece of evidence, the judge has to decide if it's reliable enough and fair enough to even be considered. It's all about protecting the integrity of the trial itself.
And this process really boils down to 5 major hurdles. First, is it even relevant? Like, does this have anything to do with the case? Second, is it authentic? Can you prove it is what you say it is? Third, is it hearsay? That's a whole complicated legal thing, but basically it's about secondhand statements. Fourth, the best evidence rule. Is this the original file or a trustworthy copy? And finally, is it unfairly prejudicial? Meaning, does it just exist to make the jury angry or biased? Every single piece of digital evidence has to clear all 5 of these hurdles.
Now, of all those hurdles, let's zoom in on the one that is often the highest and hardest for digital evidence to clear: authenticity.
The bedrock of authenticity is something called the chain of custody. Think of this as the evidence's documented life story. It's a super meticulous paper trail that logs every single person who handled the evidence, from the second it was collected to the moment it shows up in court. And if there's even one tiny, unexplained gap in that chain, that could be enough doubt to get the evidence tossed out completely.
The other side of proving authenticity is showing the data itself hasn't been changed. And this is where something called cryptographic hashing comes in. It's like a unique, unforgeable digital fingerprint for a file or even a whole hard drive. This fingerprint, this hash, is calculated the very instant the evidence is collected. If even one single bit of data is altered later on, that fingerprint changes completely. It is the ultimate tamper-proof seal.
And this technology has completely shifted the question the courts are asking. It used to be that they'd get bogged down with, well, is this computer system generally reliable? Which is an almost impossible question to answer. But now the question is so much more direct and provable. Has this specific piece of evidence been tampered with? The focus has moved from the machine to the data itself. Huge difference.
So, the evidence has made it through the gauntlet. It's been admitted into court. But that's not the end of the road. The next big question is, how much is this evidence actually worth? And this is where we need to weigh it on the certainty scale.
Which leads to this really crucial and kind of tricky question. Just because something is admissible, that doesn't make it irrefutable proof. So, after clearing all those hurdles, how certain is certain? To answer that, experts use frameworks like the certainty scale. It gives everyone a common language to talk about confidence.
It goes all the way from C1, which is highly uncertain, the evidence is pretty questionable, all the way up to C6, certain, which is that tamper-proof hashed evidence we just talked about. So for example, a single log file that's not protected, that might be a C2. But what if you have IP address logs, user account data, and phone records that all point to the exact same thing? Now you might be at a C5, almost certain. This scale is so important for helping a jury understand that not all evidence carries the same weight.
This scale also helps us understand the power of circumstantial evidence, right? So direct evidence proves a fact on its own, like a log file that shows an account was used. Circumstantial evidence needs you to make an inference, like security logs showing only one person was in the building at that time. Now, here's the key. A huge pile of strong circumstantial evidence, say a bunch of stuff at the C4 or C5 level, can often be way more convincing than just one single piece of direct proof.
And that brings us to our final step, packaging all of this careful, meticulous work and actually presenting the digital truth to the court.
This diagram really pulls it all together, doesn't it? You can see the entire journey, from the first accusation through all the analysis, all the way to the final verdict. Every single step you see here is a link in a chain of verifiable trust, and if just one of those links breaks, the whole case can fall apart.
And it all comes together in the expert report. The goal of this document isn't to point fingers or shout guilty. Its purpose is just to be a clear, objective translation of really complex digital facts, laying it all out so that, in the end, the evidence can simply speak for itself.
Which leaves us with one final, pretty big thought. As our technology gets better and better at delivering certainty, as we get closer and closer to that C6 level, we have to ask a really fundamental question. In a world of nearly perfect digital proof, does our very definition of reasonable doubt need to change right along with it?